Good afternoon or good morning to folks, depending on where you are. Welcome to the presentation Litigation and Business Strategies for 503A GLP-1 Compounding, Navigating Legal and Regulatory Risks. My name is Jesse Dresser. I'm a partner with the law firm Frier, Levitt. I'm joined by a couple of my esteemed colleagues, Martha Rumore and Matt Modafferi. So we'll start off with some quick introductions. Maybe Martha, if you want to go first, tell us a little bit about yourself and a little bit of kind of what you're going to talk about today.
So I'm a pharmacist attorney, and I'm also an ex-compounding pharmacist at a medical center in New York City. And my practice is focused on pharmacy and FDA regulatory and compliance. I represent 503A pharmacy compounders. I also represent 503B outsourcing facilities, specialty pharmacies, particularly in the area of things like border pharmacy and FDA regulated matters. We regularly counsel on the DSCSA and state-specific compounding requirements. We assess compounding practices for state and federal regulatory compliance, including USP 797, 795, 800, medical necessity documentation, advertising promotion, reimbursement issues, infrastructure, and preparing compounding policies and procedures. And we provide guidelines and standards and training for pharmacy staff with regard to compounding. So I'm glad you all had an opportunity to join us today for what is a very exciting topic.
So for myself, my name's Jesse Dresser. I've been with the firm now going on 15 years, and I've spent a great deal of that time representing not only pharmacies, but compounding pharmacies in particular. I have seen a lot of different stages in kind of the evolution of compounding pharmacies over the last decade and more, ranging from New England compounding centers through payment issues with the insurance companies to the kind of new world order that we now find ourselves in, and have been doing a tremendous amount of work on regulatory issues, on contractual issues, on business issues, compliance issues with compounding pharmacies and 503B outsourcing facilities, with a big area of focus in the GLP-1s and other weight loss products. And I'll turn it over to Matt to talk a little bit about his experience as well.
Hi, everyone. I'm Matt Modafferi. I am a partner at Frier, Levitt. And while Martha and Jesse and I kind of have the same clientele, meaning we represent compound pharmacies, 503As, 503Bs, med spas, clinics, and the like. I am on the litigation side of it. So whereas Martha and Jesse are on the compliance, the regulatory, the contracting, I'm on the front lines with the attorneys that represent some of these big drug manufacturers. And currently I'm handling litigation against them, both on behalf of compound pharmacies and med spas. With that, I'll turn it back to Jesse and Martha.
Great. So just at the outset, during today's discussion, this is purely educational purposes only. We are providing just our views and an overview of some of our experiences in doing work in the space. It's not to be construed as legal advice, nor should it be construed as forming an attorney-client relationship. In addition, any use of trademarks or copyrighted information is purely for educational purposes only and shouldn't be construed as an endorsement or promotion of any of those registered marks. So with that, Frier Levitt, we are a boutique healthcare life science law firm. We have about 50 attorneys, and we're located mainly in the Northeast, although we have a national practice. Our clients range from pharmacies to drug manufacturers, repackagers, wholesale distributors, and across the healthcare and life science continuum, including doctors' offices, surgery centers, hospitals, and others. We have a complete service for our clients and are able to provide everything from corporate to litigation to regulatory to tax to employment services and beyond for our healthcare and life science clients. So with that, I'll turn it over to Martha to talk a little bit about some of the regulatory updates that we've seen in the 503A compounding space. So Martha, take it away.
Thank you so much, Jesse. The GLP-1 market, it's massive. The market is approximately $126 billion in sales and it's going to continue to grow. It's predicted that the compound annual growth rate is about 30% for 2020 up to 2029. So, pun intended, there's an increased appetite for GLP-1s. And that doesn't even take into consideration the compounding annual sales. So for compounding, Bloomberg estimates that there are at least $1 billion in annual sales for that. So you no doubt have been reading a lot about the FDA's 506E shortage list. I would just urge you to read carefully because not everything you read is accurate. And when you're in doubt, you should always seek legal counsel. With my time with you this afternoon, I'm going to discuss the evolving landscape of 503A GLP-1 compounding with an emphasis on tirzepatide. I'm also going to review the current rules of engagement for compounding, and as well as the Outsourcing Facilities Association versus FDA Eli Lilly lawsuit. And then there's an Eli Lilly company versus FDA lawsuit that I'll just briefly talk about. And lastly, I'm going to talk about patent litigation, the current lack of patent litigation, and whether we could expect to see manufacturers assert patent litigation as the basis for a claim against 503A compounders in the future. Next slide, please. So here are your rules of engagement. This is a flowchart taken from the FDA's guidance document titled Compounded Drug Products That Are Essentially Copies of a Commercially Available Drug Product under Section 503A of the Federal Food, Drug, and Cosmetic Act. And the major premise is that to qualify for exemptions under 503A, a product must be compounded by a licensed pharmacist or physician who does not compound regularly or inordinate amounts any drug products that are essentially copies of a commercially available drug. So the guidance is very nuanced. It's very difficult to understand. It includes terms like commercially available, essentially a copy, and regularly or inordinate amounts. But it's a nice summary of what you need to know to be able to compound under Section 503A. So the first prong, the first question there on that flow chart is the comparable marketed drug product not commercially available? And if the answer to that is yes, then it's not essentially a copy and it can be compounded. If the answer to that is no, meaning that it's, it is commercially available, then the next question is the compounded drug product essentially a copy? And if the answer to that is no, then it's not essentially a copy and it can be compounded. There's certain rules there you see in that second box as to what constitutes essentially a copy. That's just the summary of it, but there's more detail between each of those. So for example, the API has the same similar or easily substitutable dosage strength. That is defined in the guidance as plus or minus 10% strength. And so is the compounded drug product essentially a copy? If the answer to that is yes, then you go to the next question, which is, was a change made for an identified individual patient that produces a significant difference for that patient? If the answer to that is yes, and if the answer is that is yes, you need notation. It either has to be on the prescription and it has to be, or if it's not clear from the prescription, then the pharmacist needs to make a call and document what that significant difference for that patient actually is. So if there is a change, there's a notation, it again is not essentially a copy and it can be compounded. If there's no change, then it is essentially a copy and the drug cannot be compounded. In addition to this guidance, with this flow chart, there's some language in there about regularly or inordinate amounts. And the FDA interprets that to mean that in order for a compounded, for something to be compounded in accordance with 503A, the product that is essentially a copy of a commercially available product can't be compounded regularly, meaning it can't be compounded at regular times or intervals, or usually or very often, nor can it be compounded in inordinate amounts. But the important point here to note is that regularly or inordinate amounts, that provision is not implicated if the compounded drug is not essentially a copy of a commercially available product. So, for example, if the compounded drug product that has the same API, dosage strength, and route of administration as a drug product is on the FDA shortage list, that's not considered essentially a copy of a commercially available drug, because by virtue of being on the shortage list, it's not considered commercially available. So keep in mind that that medical necessity piece kicks in under a limited set of circumstances if the compounded drug is not essentially a copy of a commercially available drug product. Next slide, please. So if you're a 503A compounding pharmacy, you're no doubt aware that the FDA has declared that the tirzepatide shortage is resolved as of December 19, 2024. And it's allowing 503A compounding pharmacies to compound pursuant to a grace period until February 18th, 2025. And the 503B outsourcing facilities have until March 19th, 2025. But keep in mind, again, this doesn't affect semaglutide, which remains on the 506E shortage list, as are several other GLP-1s like dutaglutide, liraglutide. Even though semaglutide is on shortage, the FDA has stated that all but one product is currently available. So if you look at the FDA website, the shortage list, it's a little confusing. They made that declaration around the time that they took tirzepatide off the shortage list. So they were probably moving to take semaglutide off the list as well. But at least in my thinking, it's most likely that the OFA litigation resulted in a more cautious approach on the part of the FDA. So semaglutide is still on the shortage list as last time I checked, which was this morning. So it is still on shortage. You're probably also aware that the 503B Trade Association, the OFA, Outsourcing Facilities Association, they're suing the FDA for that decision to take tirzepatide off of the shortage list. And I'm going to talk about some of the reasons on the next slide. But the issue right now is that grace period, that's that end date of that grace period, February 18th, is that enforceable in view of the court schedule in the OFA litigation? And keep in mind that that grace period only pertains to the ability to compound essentially a copy. So FDA could still take action regarding violations of other statutory or regulatory requirements, such as to address findings that a product may be of substandard quality or otherwise unsafe for patients. So what legal risks do pharmacists face if they continue to compound tirzepatide beyond these dates? The first one I'm going to mention is that the ability to compound tirzepatide, it has a limited lifespan. So even if the court makes certain decisions in favor of OFA, the ability to compound tirzepatide when it comes off the shortage is going to have a time limit. Even if the FDA actually loses the lawsuit, at some point, the manufacturer is going to ramp up production to prove that the drug is no longer on shortage. So that's the first thing. The second is that the manufacturer, which has now joined as a defendant in the OFA lawsuit, has been very aggressive in trying to stop compounding of tirzepatide. There have been several rounds of cease and desist letters to pharmacies, and they've sued a number of pharmacies. My colleague Matt is going to go into detail on that. So the second risk is that of manufacturer litigation, and whether or not the manufacturer is likely to succeed on the merits is kind of irrelevant, but there is a risk of litigation. Next slide, please. So these are just some of the claims in the 503A GLP-1 litigation. Again, my colleagues, Matt is going to speak about this. The only one I really wanted to mention in depth here is the I'm going to talk about the GLP-1 patent infringement cases. And what I want to mention is that they pertain to paragraph 4 challenges, which occur when an abbreviated new drug application is filed for generic version of a brand product. So none of the cases involve a claim of patent infringement by a 503A compounder. And we're going to go into the reasons why on one of my slides. Next slide, please. So the Outsourcing Facilities Association, the OFA versus FDA case. So this case has resumed. It was put on hold for a while. It's resumed when the FDA doubled down on taking tirzepatide off of the shortage list. And right now, there's pending a preliminary injunction. So OFA argued that because the FDA was making a decision that applied to the entire compounding industry, it was in fact creating a rule rather than making an adjudication. And that's a critical difference when it comes to the law, because rulemaking has a much stricter requirement than simply adjudicating. Adjudication involves disputes where rulemaking involves rights of a broad class of unspecified individuals. The American Pharmacists Association reports that 7,500 pharmacies engage in compounding, and that doesn't include hospitals and other healthcare facilities. In addition to that, there's something like 88 503B outsourcing facilities. So, at least in my opinion, it seems that it can hardly be an adjudication, and instead it represented a new legal restriction on compounding. So the OFA took the FDA to task for certain things in the litigation. They're saying that they didn't engage the public with this notice and comment period, and that is required by the Administrative Procedures Act. In other words, by making this broad decision, that they didn't follow the appropriate rules when doing so. The OFA is also arguing that the FDA decision was not based on, it was just based on the manufacturer's representation of the situation rather than on the reality. And so, for example, they said that some of the evidence from the wholesalers was waived, patients' reports of not being able to get the drug. And also the fact that the drug remained on the ASHP shortage list, even though it was taken off of the FDA shortage list. And that is another shortage list that, of drugs that are on shortage. It's got more drugs on there. So that's another reason. So latest development, and this is, you got to be really on top of this stuff, because Tuesday, February 11th, the FDA clarified the confusion about the grace period, the February 18th, the March 19th grace period. And basically, what they said is that it all comes down to how the court rules on this preliminary injunction. And so what they've said is that for a 503A, the compounding is until February 18th, 2025, or here's the big thing, or until the date of the district court's decision on the plaintiff's preliminary injunction motion, whichever is longer. So it all is going to depend on what happens with that preliminary injunction, because if you look at the schedule for the case, there's no way that February 18th, 2025 is going to be enforceable, because the hearing and everything on the injunction, everything's scheduled for like February 25th and later. And so everybody has to get their papers on time, then there's an answer to it. And so it's going to take a while. If the OFA succeeds on the preliminary injunction, then the FDA is going to be enjoined from enforcing the the grace period where the pharmacists can't compound. Next slide, please. So I'm just mentioning this case very briefly. It's one of the most recent cases to be decided, January 31st. It wasn't actually decided, it was dismissed. and it's a semaglutide case. And I'm mentioning it just for a few reasons. One is that the manufacturer sued a small compounding pharmacy. And why small compounding pharmacy and not the larger compounding pharmacies? One of the reasons is that the small pharmacies may not be able to defend themselves, and they're more likely to either lose or settle a case. If the manufacturer wins, then it establishes precedent for the next case. If they settle, however, then that doesn't establish precedent. But the courts, the other reason I mention is this, it's another in a series of cases where the court says that the claims are preempted. And what that means is that the manufacturer's claim constitutes a prohibited private enforcement of the Federal Food, Drug, and Cosmetic Act, which is within the sole purview of the FDA for enforcement. So my colleague Matt is going to go into that further, so I won't speak about that. Next slide, please. So this case is very significant. This is a case that's very different from any of the other cases that you see. Here you have Eli Lilly suing the FDA. And, there's, the last webinar, I don't know if you attended, we spoke about a lot of the efforts by the manufacturers to prohibit compounding of these GLP-1s. In addition to the removal from the shortage list, some of the manufacturers, they're trying to prohibit compounding via this list called a demonstrable difficult to compound list. So the manufacturers of both tirzepatide and semaglutide have petitions pending with the FDA to have these drugs added to this difficult to compound list. But this case, this Lilly versus FDA, it's another avenue for the GLP-1 manufacturers to try to immunize GLPs from compounding. The background of this case is that the GLPs are peptides and not biologics. Eli Lilly is filing this lawsuit against the FDA. It was filed in September 2024. They're arguing that its GLP retatrutide, which is currently in phase 3 clinical trials, is a biologic as opposed to the drug. So why is that significant? It's significant because biologics can't be compounded, so that's the reason. That's the reason why peptides that are FDA approved can be compounded. So Eli Lilly had petitioned for the FDA to categorize this particular GLP-1 as a biologic, and Lilly says that it's got 41 amino acids, and the requirement for a biologic is greater than 40 amino acids in size. So, whether or not Lilly succeeds here, because the FDA is now interpreting the 40, it says they're interpreting it as 40 alpha amino acids in size versus 40 amino acids in size. So it's $1 billion question that's hinging now on the word alpha. Is it alpha amino acids or is it regular amino acids? That limitation for alpha doesn't really appear in the text. So, versus the more broader category of amino acids. So Lilly may actually succeed here. And if they do, not only will it affect tirzepatide, but that's going to affect, a lot of the GLPs that would have this alpha amino acid. Next slide, please. So basically, we talk about patents next, the intellectual property issues. So patents grant an exclusive right, and they prohibit others from, processes of using the product, making the product. But it's not an issue if the compounding uses commercially available product. It's not an issue if the compounding uses bulk API sourced from an FDA-registered facility. It's not an issue if it's compounding within plus or minus 10% of commercially available product. But compounding essentially a copy when the drug is off the shortage list, there is a risk. And the patents for the semaglutide, they're set to expire between 2020 and 2034, with tirzepatide until 2039. Over 40 countries exclude compounding from patent infringement, excluding patent infringement in compounding is designed to both avoid limiting access to medications needed for patients and to avoid interfering with the prescriber-patient relationship. In the United States, 503A provides certain exemptions for pharmacists to permit compounding medications. One of them is that they don't have to file an ANDA because they are actually exempt from the ANDA requirements. So no patents assertions are required, and pharmaceutical manufacturers can't bring lawsuits for patent infringement. The Food, Drug, Cosmetic Act preempts 503A compounding patent infringement claims. The provision is not absolute, and the compounding has to be pursuant to all of the requirements for 503A. And so pharmacies, sometimes they find themselves not adhering to 503A. For example, they may undergo an FDA inspection. They may receive a 483 or a warning letter. And in that letter, FDA may assert that the pharmacy is distributing an unapproved new drug because it failed to obtain an ANDA approval. And so that's because they're not adhering to 503A requirements. So that is a strong risk factor that could, confound the exemption for a particular pharmacy. There also, if a pharmacy is compounding essentially a copy, does that change that patent infringement analysis? The only reason that a 503A is going to be compounding essentially a copy is if it appears on the 506E FDA shortage list. So if it's on shortage, it's not commercially available, and an exact copy can be compounded. Once it's off the list, it can only be compounded under those narrow set of circumstances that you saw in that flow chart. So looking at the stakes here, these GLP manufacturers, they may decide to bring a patent infringement lawsuit, but such a claim would unleash the full wrath of the entire compounding world. And it also could result in a manufacturer having its patents be invalidated. And as an IP attorney admitted to the USPTO, I can tell you that patent invalidation is more common than you would imagine. But all it takes is one weak claim. And that can, if they attack one claim that shows lack of novelty or that it's obvious or that it has any other issues, that's going to be an reason to invalidate a patent. Next slide, please. So I'm not going to go into this. I'm just going to show, all I want to say is that tirzepatide, there is a thicket of patents around the product. The molecule patent is going to expire in 2036. Generics are restricted until 2039. And all of the patent lawsuits to date have been paragraph 4 Hatch-Waxman lawsuits for generic companies trying to get their generics ready for approval. And with that, I'm going to turn it over to my colleague, Matthew Modafferi, who's going to speak a little bit more about the GLP litigation from firsthand knowledge.
Thanks, Martha. So I'm going to talk a little bit about what we're seeing as far as litigation trends, and then also try to provide some tips or suggestions, right, that you can use in sort of preparing for or defending or hopefully never even receiving any litigation or litigation threats from the big pharma. The litigation trends are really can be separated into 3 buckets, as I have here. On the top, the drug manufacturers are suing compound pharmacies to prevent their sale of compounded drugs. And basically the mechanism that the manufacturers have been using for that bucket is the various state unfair and deceptive trade practices acts. The second type of claim that we're seeing is a false advertising claim. Those have been generally directed at clinics and med spas, but we have seen some against the actual compounding pharmacies. And then finally, some cease and desist letters that went out to API manufacturers to try to cut off the supply chain. Next slide. So first, kind of taking them in reverse order, the cease and desist attempts, it really hasn't happened in a while. We're just seeing the manufacturers just go right into litigation. But there were some cease and desist letters that were sent to API manufacturers. As far as we know, they didn't turn into active litigation, and most likely the reason for that is most of the API manufacturers are out of the country and out of jurisdiction. We may see some action by the manufacturers, the drug manufacturers, against maybe some API distributors, but again, we haven't seen anything like that. So that bucket we can deal with pretty quickly, and I want to spend most of the time going into the advertising and the compound matters. So next slide, please. Okay, the advertising. Before we get into sort of the false advertising claims and what we're seeing in that regard, just 2 columns of simple do's and don'ts, right? The Supreme Court has said that pharmacies can advertise for compounds, but you need to be careful, right? You want to let your prescribers know that you are about patients, right? Compounded medications are allowed for a reason. But be careful about, the way that you advertise or market if you do choose to do so. And the don'ts are helpful in that regard, and there are more on the next page. But some big ones, right? Don't sort of direct patients toward the compound as opposed to the brand. Comparisons are not a good idea either. Don't cite to the brand drug manufacturer's clinical studies. We're seeing that over and over again in litigation. Don't refer to your compound as a generic, right? These are all examples. The don'ts really come down to, are you making it somewhat confusing to the consumer? That's the hook. That's the legal standard. Don't advertise the safety and efficacy of your compound. Things like that will help you to stay sort of out of the crosshairs of the brand drug manufacturers. Next slide. So that was just a slide of do's and don'ts, generally speaking. So now moving into what we're seeing as far as lawsuits and litigation against pharmacies, clinics, and spas, where the manufacturers have alleged that the entities were engaging in false advertising. This route has been largely successful for the drug manufacturers. And what we see in these cases are advertisements or social media posts that say, we have the same active ingredient as Ozempic, the same active ingredient as Mounjaro or Zepbound. Advertising about safety and efficacy, right? Saying, studies show that, however many percentage of patients lost weight. Those are citations to the manufacturer's clinical studies, and they have taken a very, very strong approach to any entity that has used or cited to any of their clinical studies. And what we hear from some of our clients is, oh, we didn't know we couldn't use the clinical studies or cite to them. But just be careful about that. You can say, the clearest way to avoid any claim or confusion would be stating what you have, right? It's a compound. Just be careful. And obviously, if you use the names Ozempic and Mounjaro, that's you're using their trademark, so that'll put you in their crosshairs right off the bat. But generally, these cases have been successful. The defendants have, most of them have settled rather than, fight these larger entities. And, so, just be very careful with who is putting, ads up. A lot of entities use an outside website designer or builder. So please just make sure that you review or talk to counsel if you're not sure about what you can and cannot say on your website or in your social media pages. Next
Yeah, and
slide.
one thing just to echo that, and Matt, this is related to a discussion we had on the subject recently, is when you're working with those outside vendors, there's many times where they will look for keywords, Google words, or other forms of SEO, search engine optimization, and what they are coming up with are great ideas from a findability and searchability standpoint, and great to optimize your online presence, but they may not necessarily be in fact aren't thinking about the legal implications of some of what it means to include some of those words. So just make sure you have that conversation with those vendors as you work with them.
Yeah, great point. And that's what we're hearing a lot, right? We're using this outside vendor, this outside website design company, and they're putting it together to get me, at the top of the Google search hit. But some of those terms might be problematic. Next slide. Okay, the third bucket of litigation that we're seeing is lawsuits against the 503A compounding pharmacies to prevent the sale of compounded GLP-1s. These, whereas the false advertising claims have been largely successful for the manufacturers, these types of claims have been largely successfully defended by the pharmacies. And how they've been successful is that the United States has sole enforcement authority under the Food, Drug, and Cosmetic Act. Private enforcement is barred. So when a manufacturer tries to step into the shoes of the FDA and enforce the misbranding or adulteration provisions of the FDCA, that should be preempted. Are we seeing that across the board? No, but hopefully we will get to a point where it's preclusive across the board, and maybe that will curb some of these lawsuits from being filed. There is a carve out for common law tort claims. I won't get into that, but it's slightly different from what we're seeing here, where the manufacturers are trying to enforce the provisions of the Food, Drug, and Cosmetic Act. Next slide. Okay, so originally what we were seeing from the manufacturers was, just generally speaking, compound pharmacies were putting out or selling a unapproved new drug. That's what they were calling the compound. It's an unapproved new drug. They then shifted gears slightly and dressed up the same claim, but in different clothes, under the guise of, State Deceptive and Unfair Trade Practice Act, right? Saying, well, okay, fine. Your unapproved new drug violates the misbranding and adulteration provisions of not only the Federal Drug and Cosmetic Act, but the state's DCA as well. And the way that they're making those allegations is they're getting your compounds, right? They're getting your samples, and they're testing them and saying, oh, we tested your product and it has certain impurities. It has bacteria. It's misbranded because when we tested it, the potency was, 20% less than, what you had on your label. And they're using that to bring these cases against compound pharmacies. Whether there's merit or not, that's on a case-by-case basis. But defending a lawsuit against a huge multi-billion-dollar company is not fun, right? So just be wary of what the manufacturers are doing. Next slide. So again, this is just that same bucket that we're talking about, lawsuits against the compound pharmacies. And these are just some snippets of some of the quotes, right? The FDCA's purpose is to prohibit the movement in interstate commerce of adulterated and misbranded food, drugs, devices, and cosmetics. So, that's an underlying basis to say the FDA should be enforcing this, not private entities. And we're seeing the manufacturers try to get savvy and just dress that claim up to avoid getting their case dismissed on implied preemption grounds. One other distinction, and this is something that I've personally dealt with in the case, is the manufacturers are arguing and citing to consumer tort cases, right? Like, I bought sunscreen and the sunscreen had less in the bottle or was less SPF than label. That's misbranding. And there's some cases out there where an individual, a consumer, brought suit against the company that put out the sunblock, for example. And because there's a duty owed to the consumer, those cases were allowed to proceed. The cases by the drug manufacturers are different, right? They are not consumers. They are alleged, they could be considered competitors, right? So they're using that line of cases, right, to try to knock off the competition. There's no duty to them. The duty is to the consumers. It's just sort of getting back to some of the arguments that are made in these cases. Next slide. So this is more now into sort of the criminal investigation sphere. We really haven't seen much enforcement by the government, whether it's FDA or DOJ. DOJ had gotten involved in counterfeit products. FDA has sent some cease and desist letters to compound pharmacies. Specifically, there were some that were sent recently because the compound pharmacies were using research grade API. So not much here, but just pointing it out that there has been some limited government enforcement. Next slide. So last slide, right? What can I do? What can we do to sort of stay out of the crosshairs, right? Couple of suggestions. One, obviously be in compliance with 503A, right? Valid scripts for patients. Use API that, has a monograph or as a component of an FDA approved drug or appears on a list approved by the FDA. But not only compliance with 503A, compliance with USP 797. Some states have differing dates by which you have to be in compliance with the new 797. So please be aware of that. You want to be in compliance. Other tips here that are listed, vet your API manufacturers, right? Really review the C of A's to know what it is that you're putting in your compound. Obviously, you'd want to get your API from an FDA registered facility. The best piece of advice, right? I guess maybe second best piece of advice, because the best piece of advice is to seek guidance from healthcare attorneys. But the second best would be the more testing, the better, right? If you're doing, for each batch, sterility, endotoxin, and even potency, great. Do as much as you can. Because again, if you have the testing and the proof, it'll always help on the back end. So I didn't leave much time for Jesse, but Jesse, I'm going to kick it over to you to take us home.
All good, Matt. All right. So turning to some of the things that I'd like to talk about, and in particular, I want to just talk high level about some of the different structures that we've seen that are out there where it involves different types of relationships with third parties, whether they be telemedicine providers, whether they be other pharmacies, whether they be outsourcing facilities, whether they be marketing groups. and just talk about what those relationships look like, as well as some of the high-level risks that you might face in compliance considerations that I don't know that everyone really thinks about when they kind of enter into these things. So there's a couple of different models we've seen. We've seen models involving a compounding pharmacy, a telemedicine provider or platform, and telemedicine actual physicians. So in this type of model where there is partial, we call this the partial insurance model. So here, the way it works is a telemedicine prescriber evaluates a patient. The prescriber submits a claim to insurance for the payment. The prescriber issues a prescription order for the product. So the prescriber is billing their time, their visit to insurance. The prescription order for the product is written. It's sent to the cash pharmacy. The pharmacy dispenses and charges cash to a patient. The other way that we've seen it is a prescriber evaluates a patient. The prescriber charges cash for that telemedicine visit. The prescriber issues a prescription for the product. They send the product to the patient's pharmacy. The pharmacy dispenses it and bills the insurer. In both those models, the reason we bring this up is you see here that there is a claim being submitted, whether it's a claim being submitted for the teleoffice visit by the prescriber, or it's a claim being submitted for the drug itself. So what that does is it's tipping off an insurance company that there's something going on here, and they don't see both sides of the claim. They don't see a claim for the telemedicine visit, and they don't see a claim for the drug. So it's putting the feelers up a little bit. So just something to be mindful of. Not necessarily meaning that there's something wrong with it, but just something to be mindful of. Other structures that are probably more common, at least in this space with the compounded products, are these cash options. So there's an all cash option that where the different stakeholders are not integrated, and an all cash option where they are. So in an all cash option where they're not integrated, the prescriber will evaluate the patient. The prescriber will charge the patient a single cash fee for his or her professional services. And these could be telehealth services, these could be in-person services, but either way, the prescriber is directly charging the patient cash, not billing the patient's insurance company. The prescriber issues the prescription for the product. It goes to one of the pharmacies, whether it's the setup pharmacy or network of these pharmacies. The pharmacy dispenses it, and that pharmacy charges cash to the patient. So again, the patient's paying cash, but you see here there are two separate point of service charges. There's a point of service charge by the prescriber, point of service charge by the pharmacy. In an integrated model, the way we see this typically operate is the prescriber will evaluate the patient. They will charge a single patient fee. The prescriber issues the prescription order. The prescriber sends the prescription order to a network pharmacy. The pharmacy dispenses it, and then the prescriber remits a portion of that single fee to the pharmacy. So here, as far as the patient's concerned, they're only making one payment. It's just that part of that payment is going to the cost of the professional evaluation. Part of the payment is going to the cost for the drug. Another framework that we've seen is a vertical pharmacy. Here, the prescriber evaluates the patient. They charge the patient, whether it's cash or insurance. They'll issue the prescription order for the product. They'll send it to their wholly owned pharmacy. The pharmacy dispenses it, and the pharmacy charges patient cash or bills the patient's insurance. So here it's just totally integrated between the doctor, the pharmacy, dispensing it. The final one that we've seen is kind of an in-office dispensing office use scenario. And this is typically done with a 503B outsourcing facility. Here, the prescriber would evaluate the patient. They would submit a claim to insurance for their professional visit. They'd issue a prescription order to an outsourcing facility. The outsourcing facility would provide the product directly to the prescriber's office, and they would administer it to the patient and charge cash to the patient for essentially for the drug. So in each of these different situations, there are different considerations. I'm going to talk a little bit about the single payment considerations, just because those are the most common. That's a scenario where, patient might be charged $150 for a telehealth consult plus a drug, or they'll be charged monthly rate of $50 to have ongoing telehealth services and to receive their medication, whatever the case is. But in both those situations, the patient is making one payment and it's covering not only the doctor's visit, but also the cost of the drug. So the first area of concern are kickback statutes, whether it's the federal anti-kickback statute or state anti-kickback statutes. These typically prohibit any provision of value in exchange for referrals. And in terms of the value, it could be anything. It could be any form of remuneration, anything of value, whether it's free services, whether it is promises to send other business, whether it is actual money, whether it's other items of value. And in terms of referrals, it doesn't have to be a straight referral. It could be construed as an arrangement for a referral. So you might not have a situation where you're actually making the referral, but you in turn are helping to arrange for a referral to be made. The anti-kickback statute at a federal level, that's going to apply to federal healthcare programs. So there needs to be a nexus between one of those federal healthcare programs like Medicare, Medicaid, TRICARE, et cetera, in order for the federal anti-kickback statute to apply. In a model where no insurance is being billed and it's all cash, it's very unlikely that that's going to be implicated, especially if there isn't some other relationship outside of the GLP-1, outside of the compounding space that's also happening between the prescribers and the pharmacy. At a state level, there are a handful of states, while most of the states apply to either state Medicaid or perhaps state Medicaid plus state commercial insurance, there are a handful of states that are what are called all-payer states. And that means that their anti-kickback statute applies not just to instances where there's insurance payment, whether it be government or private insurance, but also instances where patients are paying cash. So, if you are paying, just hypothetically, if you're a pharmacy and you're paying a doctor for every claim, every prescription that the doctor sends your way, and you're charging patients cash, even though no federal programs are involved, even though no commercial programs are involved, the fact that you're charging the patient cash can implicate some of those state all-payer kickback rules. So it's important to make sure that you're evaluating it from that perspective. The way that typically entities comply with these rules is by fitting into a safe harbor. There are a number of safe harbors that could be available. Personal services and management contract safe harbor is probably the most commonly used one. But again, it's one of those things that you have to evaluate when you're setting up the agreement, when you're setting up, particularly in the case of subscription models, to make sure that it's being structured to fit within one of those safe harbors. Another kind of ancillary to that is fee splitting rules. These essentially prohibit one professional from splitting fees with a non-professional. So, for example, a physician would not be able to split its professional fee with a non-physician. A pharmacy might not be able to split its pharmacy fee with a non-pharmacy or with someone else. They are similar in structure to the anti-kickback statutes and their safe harbors. And generally speaking, you can comply with the fee splitting rules if you're complying with an applicable safe harbor. But again, it's something that you're going to have to check on each one of these types of models to make sure you're doing it appropriately. You also see kind of the flip side of anti-kickback is self-referral. These are usually professional rules applicable to the physicians themselves. Again, at a federal level, it's only going to apply to federal programs, Medicare, Medicaid, et cetera. So it's probably not going to be applicable in cash models. But a number of states do apply it to all payer situations or any form of self-referral. So if the physician has a financial interest in a pharmacy that they're sending it to, it could be implicated even if it's a pure cash model. And there are some states that limit the types of referrals that have to be made. So, for example, a referral of prescription drugs might not trigger that self-referral requirement, like, say, a referral for an MRI or surgery or something. There's also issues around the unlicensed practice of pharmacy. You want to make sure that each of the stakeholders along the way is not being engaged in the improper unlicensed practice of pharmacy or unlicensed practice of medicine. There's also a couple of states that deal with prescriber resale of drugs. For example, in New Jersey, the Board of Medical Examiners limits the ability of physicians to resell or to mark up drugs when they do the resale. They indicate that you can't mark it up more than 10% of your cost. Other states limit the amount that physicians can dispense or provide at any given time. Sometimes it's limited to, say, 72 hours. So another area of consideration you have to look at when you're setting up these types of models. There's also, from a telehealth perspective, there are several things that need to be considered, including a licensing status. Some states, you just have to tell the state that your telephysician is performing telehealth services. Other states, you need to get a limited type of license. In some states, you need a full separate telehealth license in order to practice as a telehealth provider. You also have to make sure that that telehealth provider, that doctor, is creating a bona fide doctor-patient relationship. Some states have specific rules for modalities of care, whether it's synchronous visits or asynchronous, meaning if you have to be, the prescriber might need to be on the phone with the patient real time, collect their information, be able to communicate, versus asynchronous, where you could store and forward and have the prescriber review at a later time. There's also the concept of audio only versus audio video. Some states require a phone call. Some states require actually being on camera and communicating with the patient that way. Another issue is reviewing direct patient information versus reviewing a readout or summary of the information that the patient has provided, making sure that you're complying with the adequate levels of care in order to render a valid prescription. And then there's also issues about prescribing solely based on a questionnaire that you want to make sure that your model is being set up properly to account for. Other issues include the corporate practice of medicine, making sure that the entity that's providing the medical care is a proper medical practice, like a PC, in some states cannot be owned by anyone other than a licensed physician. And there's also sometimes issues around who can control a practice, whether a non-clinician can control the practice of medicine or the provision of care. So just make sure that if you're establishing these models, you're also considering corporate practice of medicine rules, because that's an area where we've started to see a lot more scrutiny of these types of models. The final thing on these types of models I'll mention is the anti-kickback statute as it relates to the dynamics between the doctor, the patient, and in some instances, marketers. So a lot of these models are built off of marketing teams that promote this to patients through social media, Facebook. They do it to outreach through different community events. So you want to make sure that if you are using marketing of any kind, that you are engaging with those marketers appropriately, that you're compensating them appropriately, and not running afoul of state or federal kickback rules or fee splitting rules when it comes to how you're engaging in compensating those marketers. So just a couple last minute miscellaneous items I'll touch on. We are seeing a lot of continued interest among employers and other plan sponsors exploring compounded GLP-1s as a formal or informal benefit for their employees. We've seen models where employers are looking to sponsor some of these limited benefit programs to as an alternative to coverage of some of the FDA approved commercially available versions of these products. There are some unique considerations there, including ERISA compliance and HIPAA compliance that come into play. So definitely make sure that you're closely examining and scrutinizing those from a legal compliance standpoint if you're interested in exploring those. We've also seen on the commercial side the growth of folks looking to combine the benefits of 340B with weight loss and looking to take advantage of some of the 340B pricing that might be available on those commercially available products. In addition to your run-of-the-mill kickback and self-referral compliance issues, there's also 340B compliance issues that come into play. So I'd encourage folks to communicate with a competent attorney about those types of models if they come up. And this is something that Martha mentioned earlier, and we've seen a growing focus on too, is the role of these so-called research use only products. These are products that are not labeled or even necessarily manufactured for human use. They are labeled for research use only. There's become kind of this underground industry and support groups and discussion boards people looking to access these products because they are much cheaper than other products, but there are a host of regulatory issues ranging from FDA issues to Board of Pharmacy issues and beyond. So I'd encourage anyone that has been approached or has considered research use only products to speak with competent counsel to ensure that they are in compliance with those types of requirements. So
Jesse, can you just
Yeah.
briefly talk about just a model with a central fill agreement, a 503B selling to 503A, and how is that structured? I know we're
Yeah,
at the last
that's
minute
something
here.
that we've definitely encountered for sure, which is a scenario where a 503B outsourcing facility is able to produce certain products and provide them to a 503A or other pharmacy for subsequent dispensing. It's been clear for a long time that 503B can provide to a healthcare provider for administration. You know, for example, providing a sterile injectable for administration by a physician in a surgery center, let's say, or a sterile bag for infusion in a hospital, right? That's been well established. It's been a little bit gray when it comes to a 503B compounding a product, delivering it to a pharmacy who then subsequently dispenses it to a patient who can then take it home and self-administer. That's been a little gray at the federal level, but the FDA came out with guidance about 2 years ago at this point that suggested that they would allow for a 503B outsourcing facility to supply a 503A or other licensed pharmacy a compounded product for subsequent dispensing to the patient. But questions abound as to how to do that compliantly within the bounds of state Board of Pharmacy requirements, because ultimately it's pharmacy dispensing, it's governed by state Board of Pharmacy rules, and it's something that the states unfortunately haven't really caught up with when it comes to how to regulate this, whether to explicitly permit it, whether to be silent about it, whether to come up with kind of alternative framework. We have seen folks look to the concept of central fill as a good analog between that. And so if you are contemplating a 503B to 503A to dispense to patient model, I encourage you to make sure you're speaking with counsel that knows about your particular state's rules when it comes to redispensing, when it comes to sourcing your products, and potentially even when it comes to central fill.
Thank you.
So with that, we are at the top of the hour. If you'd like to pose questions to us, we can certainly do our best to get back to you and maybe even post some of the answers on our social media and our webpage. Our contact information is here. We do encourage you to reach out because it is a very, very, very dynamic time. There's a lot changing at a very, very fast pace. Even just this week, the FDA came out with additional kind of clarification and guidance. So definitely encourage you to stay informed and to speak with competent counsel.